Taoiseach should also, once and for all, respond to the ongoing question surrounding the allegations contained in Micheál in 2003 that he was a host of a fundraising dinner only 2 days before the second mobile phone licence was awarded, at which apparently one of the major bidders for the licence was present. When asked about this by journalists, the Taoiseach, by then already leader of Fine Gael, refused to comment, and there has been no comment in the 8 years since then. The Taoiseach was involved in Fine Gael fundraising at the time and respected this work enough to appoint one of the party's trustees to the board of Bord Fáilte on his final day as a minister in 1997. And we all know how seriously the Taoiseach takes ministers making appointments during their final day in office. Given the clear guidelines to which he and all members of Cabinet agreed on March 2, 1995, the Taoiseach should tell us the names of the 2 witnesses who attended this meeting and supply us with the written record of the meeting. If there were no witnesses and there is no record, he should explain why. In regard to the now infamous Telenor cheque, the Moriarty report has identified a number of troubling issues that requires answers from Fine Gael ministers, including the Taoiseach. First of all, people should be in no doubt about why there was a major donation to Fine Gael by a company involved in a lucrative commercial licence awarded by the state. In the words of Dennis O'Brien Sr. in his evidence to the tribunal, the donation was given to Fine Gael because, quote, Fine Gael asked for the donation. It was rooted, as it was, he said, to, quote, ensure confidentiality. The proposal for a fundraising dinner was outlined initially in a letter of 4 July 1995 to Minister Michael Lowry. That letter identified that those attending the dinner should include the Taoiseach and Ministers Lowry, Barrett, Yates and Kenny. The very specific purpose of the dinner was not disinterested support of Fine Gael, but to be sold as something more. The letter stated that it was to be targeted at those who wished to, quote, make a definite contact and to avail of the opportunity to discuss their future within Ireland under a Fine Gael government. The Taoiseach needs to clarify, and I think he has clarified, was he at the dinner and who actually attended that dinner on behalf of the Fine Gael party at a senior level. The Moriarty Tribunal refers critically to a $50,000 cheque as a covert routing of funds from HEAnet Telenor to Fine Gael. This payment was made in a clandestine manner to an offshore account to ensure it remained hidden from public view. In stark terms, in paragraph 361, the report says the payment was made in a manner which, having regard to its false and misleading documentation, the initial payment to an offshore Jersey account and the eventual delays and misrepresented form of transmission to Fine Gael was secretive, utterly lacking in transparency and designed to conceal the fact of such payment. In regard to the Telenor cheque, Fine Gael should explain why there was such a delay in returning the donation. According to the report on the 2nd of March 1998, Fine Gael decided that it would return the donation to Telenor. However, as the report records at paragraph 636, the donation was not returned until March 2001. And why did this take over 3 years? Since the publication of this report, the Taoiseach has sought to make a virtue of the fact that his party returned the covert $50,000 donation and waived legal privilege. But the facts are that this only ultimately happened when the donation was publicly exposed and it was clear that the Moriarty Tribunal would be investigating it. Prior to this, Fine Gael had attempted to hide this donation from the Moriarty Tribunal by getting a senior counsel to advise on whether or not it was reportable. If you read the evidence of the former Fine Gael General Secretary Jim Miley to the Tribunal, you find that the idea that the cheque fell outside of the terms of the Tribunal was first suggested to Fine Gael by HEAnet's public relations representative. As Judge Moriarty has reported, the clandestine circumstances of this donation would have remained hidden from public knowledge had it not been for media disclosures in 2001. The Taoiseach would be well advised to talk to his own party's current General Secretary on this matter. In 2001, Tom Curran said that the party had decided not to report the donation to the Moriarty Tribunal because it would have been politically disastrous. He said that he had feared if the donation was revealed, a connection might be made between Fine Gael and the granting of a mobile telephone licence to HEAnet Digifone. Justice Moriarty draws a damning conclusion on Fine Gael's concealment of the Telenor cheque. And paragraph 3.63 reads, "No person or entity connected with the payment saw fit to notify the Tribunal Office, notwithstanding a substantial degree of knowledge of its clandestine circumstances and proffered return. And it is likely that without the media disclosures that occurred in 2001, the matter would have remained hidden from public knowledge." The entitlement of such persons to seek and act on legal advice is not in question, but it is nonetheless viewed by the Tribunal as regrettable that no such disclosure whatsoever to a public tribunal of inquiry transpired. Whilst allowance is made for the factors mentioned at 331, this observation nonetheless is seen as applying to Fine Gael, unquote. For the Taoiseach to claim, as he did again today in the House, that Fine Gael has been commended by the Tribunal is a deliberate misrepresentation of the report and a refusal to acknowledge a clear and serious finding of evasion against the Fine Gael party. On RT's prime time on the day the Moriarty Tribunal was published, Minister Rabbitte claimed that the report expressly exonerated the other members of the Fine Gael Labour government at the time. This was repeated by the Taoiseach again in the House. The report does nothing of the sort. Beyond this spin, it is very clear from the report that the responsibility rests upon all of those ministers who were members of the Cabinet in 1995 for how they allowed the process they agreed in March of that year to be subverted. The Tribunal report states in paragraph 1619 that then Minister Lowry proceeded to bypass consideration by his Cabinet colleagues and thereby not only influenced but delivered the result in favour of HEAnet Digifone. It seems some ministers are seeking a pardon for themselves on the basis of this statement. But the question that has to be asked is how ministers allow themselves to be bypassed. Given the conspicuous nature of HEAnet's lobbying and Minister Lowry's advocacy of their case, why did they sit back and say nothing? It is documented in paragraph 48.3.1 that the meeting at which Micheál Lowry obtained political clearance to announce the winning consortium of the GSM licence prior to it receiving full Cabinet approval was actually a meeting of the Aviation Committee. It was not even a properly convened Cabinet committee, and the issue of the mobile phone licence had no business being discussed at it. The Moriarty Tribunal reports in detail how the decision of the Fine Gael and Labour government to award the licence was made on the 25th of October 1995. Judge Moriarty reports at paragraph 48.5.5 a private conversation between former Taoiseach John Bruton and Minister Micheál Lowry. They then met with Dick Spring, Princess de Rossa and Rory Quinn. At that meeting, Micheál Lowry said that HEAnet Digifone had won the competition. Deputy Lowry also recommended that he should proceed to announce the result forthwith, rather than postpone the announcement until after the result had been considered by Cabinet at a meeting scheduled for the following day. This was approved. Judge Moriarty is highly critical in his report of the informality by which this crucial government decision was taken, and he states at paragraph 48.6.6, in securing what was de facto government approval, otherwise than through the route of bringing a recommendation to Cabinet on foot of an aide memoir or a memorandum for government, or even by deferring the matter to the scheduled Cabinet meeting the following day, all of the procedures which had so carefully been put in place by Mr Bruton and his colleagues when the Rainbow Coalition entered government were rendered of no application to the GSM decision. In consequence of the approach taken by Mr Lowry, the opportunity for scrutiny or consideration by his Cabinet colleagues or their advisers was significantly curtailed. In effect, what occurred was that the party leaders of Fine Gael, Labour and Democratic Left, together with Minister Rory Quinn, acquiesced to Micheál Lowry's fast-track proposal that the result be announced immediately, rather than being considered by the full Cabinet. A number of questions arise from the rushed and ill-informed decision of the Cabinet Committee and the failure of the full Cabinet to consider the decision. This was a widely publicised announcement. It was the largest commercial announcement ever made by the Irish Government. Why did the members of that Government not ask why the decision did not come for discussion at Cabinet before it was announced? The Taoiseach, as well as Ministers Rory Quinn, Brendan Howlin, Richard Bruton, Michael Noonan and Pat Rabbitte, were members of that Cabinet. Why did none of these ministers insist, in accordance with the procedure, that this decision should come before Cabinet for discussion, particularly given the knowledge that some of them had, that the spirit and content of the March guidelines had been broken? Did the failure of this matter to come before Cabinet for discussion not raise a question in ministers' minds as to the orthodoxy of this decision? As ministers who were aware that this decision had been made, but who were also aware that it had not been discussed by Cabinet, do these ministers now accept that they failed in their duty to scrutinise the contest in any way? We know that the scheduled Cabinet meeting on the next day, the 26th of October 1995, simply noted the decision that had already been made. And the report states again at paragraph 49.01, the decision was duly noted by Cabinet, which procedure was in the circumstances no more than a formality to ensure substantial compliance with the conditions of the government decision of the 2nd of March 1995, which had authorised the process at the outset. Did no one at that Cabinet ask why this decision was not being discussed at Cabinet? Did no one inquire as to whether they could have a report from Minister Lowry on the competition and how it progressed? The report also raises critical issues about the evidence given to the Tribunal by Minister Phil Hogan. The position on this matter, which is unequivocally set out in the report, is as follows. Mark Fitzgerald, Fine Gael Treasurer during the critical period, gave evidence to the Moriarty Tribunal that he was asked to attend a meeting with Denis O'Brien in Lloyd's Brasserie on 17th of October 1995. He said that when he arrived, he was surprised to see that also present were Fine Gael Chairman Deputy Hogan and the late Deputy Jim Micheál. He says that he was asked questions about the licence and whether he had heard anything about it from Micheál Lowry. It is evidence that this discussion took place while Phil Hogan was present with them at the same table. Deputy Hogan gave evidence to the tribunal 2 days later and stated that as far as he was concerned, that meeting did not take place, or if it did take place, he had no recollection of it. However, his primary evidence was that it did not take place. In his evidence to the tribunal, which is available on its website in the transcript for day 237, the Minister said that he would have remembered such a meeting with Mr O'Brien. That was a clear conflict of evidence that Judge Moriarty had to resolve, and he resolved it in favour of Mark Fitzgerald. Consequently, in respect of the Minister for the Environment's suggestion that the meeting never occurred, that sworn evidence has been rejected by the tribunal. There is nothing surprising in this, particularly given the unchallenged fact that Minister Hogan was personally involved in receiving for Fine Gael a large donation from Denis O'Brien and HEAnet at a time when he was aware that HEAnet was competing for an immensely valuable state licence. If you take the time to read the transcripts, you will see the futile effort undertaken by counsel for Denis O'Brien to undermine Mark Fitzgerald's evidence. It is now incumbent upon the Taoiseach to give his views on the credibility of a government member whose evidence has not been accepted by a tribunal established by the Oireachtas. The failure of the Taoiseach to do so has reinforced the impression of a Fine Gael party that believes that accountability is for other people, that standards are to be demanded of others. The Taoiseach talks a lot about change, but what change is he showing in his failure to talk about how he and others in Fine Gael ignore their own guidelines and engage directly with bidders for this licence and both sought and received substantial donations? From the outside, we see Minister Hogan still central to Fine Gael fundraising and as recently as last month refusing to answer questions about who they were targeting for funds. We see the person who was Michael Lowry's closest advisor in 1995 installed as the Taoiseach's closest advisor today. We see ministers leaving chairs vacant on important media programmes rather than run the risk of answering questions. The Taoiseach and his ministers want to draw a line but admit no errors. They want to propose reform, all of which is ready to implement and agreed by all parties, but do not want to admit their part in practices which need to be reformed. They want to operate to a grossly hypocritical tactic of talking about accountability for the past of every party except those that make up the government. In conclusion, Ceann Comhairle, I want to say that Deputy Lowry was fully entitled to be heard by the tribunal and to expect the Dáil to acknowledge this fully. This was done for 14 years. The publication of this report fundamentally changes the position. The request that we wait to hear all the evidence no longer holds. He has indicated that he will do nothing other than launch more attacks on Justice Moriarty and the entire judiciary. For our part, we believe the key findings of the report. We therefore believe that Deputy Lowry should consider his position and resign from Dáil Éireann. If he chooses not to do so, we will propose a motion expressing the will of the Dáil on this matter. This was done before in the case of the late Liam Lawler, and while the all-party motion did not cause his resignation, it did mark an important public statement of standards by this House. I have instructed the Fianna Fáil whip to make contact with his counterparts with a view to bringing forward an agreed motion in government time which calls on Deputy Lowry to voluntarily resign his membership of Dáil Éireann. I would expect and urge the cooperation of every member of this House in the speedy resolution of this motion. We will also continue to seek a forum where real questions can be asked of the ministers who allowed the awarding of the largest state licence in our history to be completed in direct contravention of the guidelines they themselves agreed. The Moriarty report is a lengthy, detailed and subject to unprecedented attempts to misrepresent its contents. It falls to us all as members of Dáil Éireann to stand against this campaign and show that we are capable of acknowledging and addressing serious failings when they arise. Only then will our collective and individual promises of change be realised. Thank you, Ceann Comhairle.